In 2005, Congress passed a new bankruptcy law that made dramatic changes to the existing bankruptcy laws and its practice. Some provisions of the new bankruptcy laws had a deleterious impact on the rights of debtors. Other provisions worked to benefit these same debtors. The new bankruptcy laws require all debtors to acquire a credit counseling certificate before filing bankruptcy. A credit counseling certificate designates that the debtor attempted to enter a credit counseling program, but that his debts were such that bankruptcy is his only remedy. After the bankruptcy is filed, the debtor must also obtain a debtor education certificate, designating that the debtor received counseling designed to give the debtor the financial tools and knowledge to avoid bankruptcy in the future. Our office assists its clients in the completion of these requirements. The new bankruptcy laws provide for a means test to determine whether a debtor's income disqualifies him from filing a Chapter 7 bankruptcy. If a debtor's income exceeds the income limit prescribed by the means test, the debtor must file a Chapter 13 bankruptcy. The means test then determines how much the debtor must pay his creditors through the Chapter 13 bankruptcy plan. Under the old bankruptcy laws, if a debtor owned an automobile and owed the finance company more than the fair market value of that automobile, the debtor could pay the true market value of the collateral through a Chapter 13 bankruptcy plan. This permitted the debtor to greatly reduce the monthly payment committed to the finance company and enjoy considerable savings on the automobile loan. This process is called valuing the collateral, because the debtor only pays the true market value of the collateral. Under the new bankruptcy laws, in order to value an automobile, the debtor must own that property for 910 days, or approximately 2.4 years. If the automobile loan is a non-purchase, money-secured interest loan, meaning the debtor owned the automobile and later borrowed money against it, the 910-day rule that may not apply. If a debtor wishes to value personal property other than an automobile, he must own the property for at least 1 year. Personal property can include not only household items, such as furniture or a television, but may also include mobile home, provided that the home is not attached to real property. The new bankruptcy laws have changed the homestead exemption as well, the exemption for retirement accounts, and other modifications. To address all the changes could occupy volumes of pages. Mr. Weller can meet with you personally to inform you on how various changes in the bankruptcy laws may affect you personally.